Good afternoon and welcome to JEG Law. We're going to continue our discussion on non-immigrant investor options through a discussion of L1A non-immigrant visas or status for intercompany transferees. The L1A non-immigrant intercompany transferee visa or status is commonly used by investors in startup companies whose nation of origin does not have a qualifying investment treaty with the United States. The investment capital, while important, is not our only focus here. Rather, an L1A visa or status requires an analysis of the applicant's role as an executive or high-level manager within an international business entity before and after coming to the United States. Adjudicators must analyze the structure of the international business organization as a corporate family to qualify an applicant for L1A non-immigrant status in order to ensure that the applicant's foreign and U.S. companies are sufficiently related. Generally speaking, the L1A is a flexible non-immigrant visa that has been traditionally useful for multinational corporations to transfer executives and managers to U.S. operations. Yet, L1A status is equally useful to entrepreneurs who own sole proprietorships or group investments in different countries and in the United States. So, on one hand, the relationship between the U.S. and foreign business entities may be close, as exemplified by a single multinational corporation conducting business in both countries. On the other hand, affiliated companies may be loosely connected, as exemplified by one individual or several individuals in common playing an executive role over two different sole proprietorships. Moreover, affiliated business entities need not conduct the same line of business nor conduct international trade nor commerce with each other, as is required for treaty trader visas. The relationship of the company in the home country must be related to the company of the United States, as defined under the Internal Revenue Code, as a parent, a subsidiary, a branch, or an affiliate. Given these requirements, international entrepreneurs may wish to start up a new business or associate an existing business in the United States through a foreign business that pre-existed the L1 application. An applicant for admission as an L1A non-immigrant must serve as a manager or an executive for one continuous year outside the United States within 3 years of being admitted to the United States in L1A status. The 1 year of continuous employment outside the United States prior to admission need not occur in the same country. It can occur in several different countries as long as it's outside the United States. But with this in mind, an L1A investor in a startup business can purchase the foreign company they had served as an executive or high-level manager in order to create the qualifying relationship. L1A non-immigrant intercompany transferee executives must perform complex oversight and policy-making functions in the U.S. company that requires such an executive. L1A managers are responsible for complex oversight of daily operations and policy implementation within their company unit or division. Managers of non-supervisorial employees, otherwise frontline managers, will not qualify. However, managers of professionals with technical functions will typically qualify as L1A managers even though they don't directly manage other personnel. An L1A non-immigrant intercompany transferee visa is granted up to 7 years to managers and executives. An L1B intercompany transferee visa involving workers with specialized knowledge, which is knowledge that is unique or proprietary to a company, is granted for 5 years. An initial grant is generally for 1 to 3 years. An initial grant of L1A non-immigrant status is generally from 1 to 3 years for 2 reasons. First, the U.S. government will abide by reciprocity agreements with the country of the foreign national to determine the length of the first grant. Also, the amount of capital invested in the U.S. company is to be considered. Extensions are granted for periods of 2 years, so long as U.S. and overseas operations remain in existence and the qualifying relationship is maintained between both of them. Extensions of L1 status differ little from the initial application, yet be aware that any L1A non-immigrant who does not apply to immigrate through an independent and distinct procedure within 7 years of initially being granted L1A status must depart from the United States for at least a year before being allowed readmission in either L1A or L1B non-immigrant status. L1A transferees have always been able to adjust to permanent resident status under the EB-1C classification, where U.S. and foreign corporate operations are stable, profitable, and remain well established. Yet, L1B transferees must change to L1A status in order to be able to do the same. With this in mind, investors in new U.S. companies or new divisions or operations within existing operations are ill-advised to prematurely apply to just status. The use of L1A status for investment-based immigration requires a business startup that fully pays its taxes in the United States. So in review, the startup company must directly hire enough employees or indirectly use the labor of subcontractor employees, or oversee employees with highly technical or complex functions so as to warrant true executive or sufficient managerial capacity. Equally important is that the foreign company and the startup company be appropriately related and remain in operation. Once the U.S. government is satisfied that the new company is bona fide and solvent, scrutiny is directed towards the L1A visa holder's function as an executive, manager, or employee with specialized knowledge. If these conditions are met, startup costs for an L1A visa or correlative status may be substantially less than that required for the E2 visa. This is because the amount of capital invested is not directly at issue, as is the case with the E2 treaty investor visa. This makes the L1A visa usually more cost-effective, yet more lengthy to process for many investors where permanent resident status is the goal, compared to the E2 visa en route to the EB-5 immigrant investor visa, to be discussed later, when looking at capital invested in startup investment costs. Finally, spouses and children may accompany the principal visa holder in L2 derivative status. It is important to note that the L2 spouse may apply for and be granted employment authorization. Although not authorized for employment under this status, derivative children may attend any public or private school without restriction. And where multinational corporations have established operations both within the United States and the foreign country, several managers or executives performing the same kind of employment may be sponsored for admission into the United States on the same petition. This is called a blanket petition, saving time, legal fees, and filing fees. Thank you for joining us during this conversation. We're going to be talking next time about immigrating through investment to the United States. Take care.